I'm attorney Phil Jusino, and this is Finding Common Ground here on Altice Channel 115. Got a great show planned for this beautiful Saturday. I have Jeffrey Deskovic in the chair next to me. He's going to be my co-host for today. Got a lot of great topics. Jeff has been a guest on my show previously, so if you've watched the show before, you'll see him and you'll recognize him right away. Just for my audience to know, I will be going back on 103.9 FM, LI News Radio. I'm probably going to start on September 21st. It was going to be September 14, but I have an important case in court, and the show starts at 5, so I'm not so sure I'd be at the airport to do my radio show at 5 o'clock. So we're probably going to start on the 21st. That will be called Phil Jusino Drive at 5, and that will be Sean Hannity's last hour that he used to do at 103, 5 to 6 o'clock. It's going to be a great show. Call in. I'm going to have Jeffrey on at some point. I'm going to have Marty Tankliff, Congressman Zeldin. We're going to have a great time doing that show. But for today, we're going to talk about the wrongfully convicted, things Jeff is working on, legislation, cases. So I'm going to bring him in right now. Welcome aboard, Jeff. How are you?
I'm great. Thanks for having me.
Good. What I wanted to do, and we're not going to dwell too much on the past, we're looking forward, but so the audience can understand a little bit about you, get a little context. I always like to have context, even for me, so that they know who they're listening to. Now, in 1989, there was a murder and a rape committed.
Yes.
And 1990, you were arrested and charged with those crimes.
Correct.
You were ultimately wrongfully convicted. I'll put the word wrongfully right out because obviously you didn't do it. And you served about 16 years in jail.
Yes.
Now, during that time, I'm sure motions were made and appeals and all of that. And at some point, so right now the audience understands you did 16 years in jail for a crime you did not commit. Somebody, in fact, was later convicted.
Yes.
So because of that wrongful conviction, that other person was out free for those 16 or so years, and they committed another murder, correct?
Yes, but to specify, he was free for an additional 3.5 years, and at that point he killed a second victim, was caught for that, and then he was incarcerated. So for about 12.5 years, we were both concurrently imprisoned, albeit in different prisons.
Got it. And because of that wrongful conviction, it damaged your life. Didn't destroy it because you're here today and doing great things, but it damaged your life. It affected your family, and it affected certainly the family of that next victim.
Absolutely.
That was killed by the murderer in the first case.
Yes.
So it has a profound, in fact, before the show we were talking about, it has a profound effect. It's not just the wrongfully convicted. It's the people that are out there that did the crime and future victims. Has a profound effect. Now, I do want to talk a little bit about the past in this respect. At what part of your life, you're sitting in jail, right? You're trying to make the best of it. You're hoping you're going to get out someday. And you're one of the lucky ones. There are a lot of people that never see the light of day. Marty Tankliff was another one that was lucky. And it turns out he served a similar amount of time to you, and he became an attorney too. So these people are coming out, like yourself, with a goal, a purpose. But when did you, at some point, decide, I want to be a lawyer?
Originally, in my teenage years, I wanted to be a lawyer because...
so before this all happened to you?
Correct. But towards the tail end of my incarceration, I decided that I wanted to be a lawyer specifically for the purpose of freeing other people who are wrongfully convicted, whereas that wasn't the goal when I wanted to be a lawyer before. I thought I was going to do personal injury law.
Okay. And when you decided you wanted to be a lawyer and you wanted to do this, did you think it was a pipe dream, or did you think, I hope to get out of here? Because obviously if you don't get out of there, and even if you got out of there at some point, if you're a convicted felon, it's going to be much harder, almost impossible, especially for what you were charged with, to become a lawyer. So even if at 16 years they let you out, or whatever, to become a lawyer would have been a pipe dream. Did you think it would be a reality when you thought about it?
I went both ways on that. At times I thought that it was a pipe dream, and at other times, being optimistic, I did not. So I kind of vacillated back and forth. But it was crystal clear to me, as you correctly point out, that if I was to leave prison on parole rather than being exonerated, that the dream was pretty much over.
Right.
As to my thinking at that time. Although I quickly want to point out that there have been a number of people who have graduated law school and got admitted to the bar and practiced law, even with convictions. But you're right, nonetheless, that the odds of them agreeing to let me do that with a murder and a rape,
right,
the rape being the key part of that,
exactly,
it would have been virtually impossible. Not totally, but pretty damn near close.
Now, there's a thing in the law you're aware of, relief from civil disabilities, which a judge can sign, and it would remove, let's say, a governmental agency's ability to give you a license. They can give you that license. But let's say a guy had a DWI, driving while intoxicated, a felony. He would have a better shot.
Yeah, obviously.
At getting cleared to practice law than what you were charged with.
Correct.
Because I don't think they'd want to touch that with a 10-foot pole.
I agree.
You know, maybe, like I said, maybe some other type of charge, but anyway. So this is another question I like to ask people that are wrongfully accused, convicted, I should say. Let's say at some point you're sitting in jail, and let's say at the 10-year mark, attorney walks in to visit you, and he says, I can get you out today, but you have to admit that you did this, or you can't say you didn't do it. So in other words, a DA can get their pound of flesh out of you, but you will come out still a convicted man. Would you have taken that?
No, and I'll tell you, I had my own brush with that in reality. I mean, obviously, no attorney walked in and said that to me, but my brush and where I came close to that at was that I had to make a decision if I was going to take and complete the sex offender training program,
right,
which was a program that the parole board wanted me to take. So that they felt I addressed the crime.
So you couldn't get parole unless you took it.
And that had a guilt admission requirement tied to it. And then secondly, when I actually made the parole board appearance, you know, I know that the parole board, they want to hear you express remorse, take responsibility, show insight. And if you don't do that and you instead stand on your innocence, then there's a pretty good chance they'll deny you parole, thus extending your already unjust prison stay. So I had my two brushes with that in that vein, and I stood on my ground. I did not take the program, and when I went to the parole board, I in fact maintained my innocence. Now, I paid the price for that. I did an extra year of imprisonment before I was exonerated, but you know, I can look back at that, Phil, and that's those two things are two of the best decisions I ever made in my life.
You held true. Now, you're right. If you don't say, I did this, unless you're Morgan Freeman in Shawshank Redemption, you're not getting out. For the most part, they're going to say he hasn't learned his lesson, he won't take responsibility. But that's got to be the hardest thing for an innocent guy sitting there, and especially if you're told by an attorney or someone, we can get you out, but you got to take this class, you got to admit this. I don't know what I would do. You know, I'm a pretty strong in my convictions. You probably know that by now if you see my work. And I don't think I could say I did something, or go to a class and sit there and say, yes, I raped somebody, so let's get through with this thing. I don't know what I would do.
I understand what you're saying, and you're right. It is very difficult, and I did wrestle with it. But my line of reasoning at that point, though, was, you know, they offered me to plead guilty after the trial was finished, but before the verdict was rendered. They offered me a 5 to 15, and if I would have taken that, I would have been home by now. So I'm 15 years in already. I've done my minimum of 15 in life. So if I was going to do that, I would have did it back then. So I stood on it now, and look, you know, come hell or come holy water, I'm not admitting guilt to the parole board. So if that means I'm going to die in there, then, you know, so be it.
Now,
that's a hard thing to say, though.
I know.
Don't get me wrong.
I know.
I'm acknowledging the human side of what you're expressing. That is a hard thing to say, but, you know, I said it. And not just theory, I did it. I walked it.
Now, when you were offered that 5 to 15 early on,
yes,
did you consider it?
Briefly. Sure, I did, briefly.
You discussed it with your family?
I did.
And did they want you to take it so they'd see you in a number of years?
No. My uncle, actually, who was a marshal of Yonkers, when I mentioned it to him, I thought he would be the best person to consult with. He rather matter-of-factly, he said, did you do it? And I said, no.
Then you have no choice.
And he said, well, then you don't take it.
Now, just quickly, I know we're still delving into the past a little bit, but these are interesting topics, and I think it's important. Did you get, I know you were convicted, okay? I know that. Do you think you got a fair trial, or was the deck stacked against you in some way?
The deck was definitely stacked against me. Do we have a moment? I'll just quickly mention.
Sure.
All right, so it was stacked against me in the following respects. So first of all, the police officers, they didn't give completely truthful testimony. So I was, the only evidence they had against me was a coerced false confession. And the police left the threat and false promise out of their narration of that interrogation. So it was stacked against me in that aspect. It was stacked against me in another aspect that my public defender, he he never put my alibi witness on the stand. He never used the DNA, which excluded me before the trial. He never used that to argue that proved the confession was coerced and false.
Why not?
I don't know. And then he took a scattershot approach with respect to addressing the confession. So at times he was arguing to the jury that the confession never happened. At other times he was arguing it did happen, but it was coerced.
Inconsistent.
Yes. So come on, his credibility went out the window all over the pick a lane and go down it.
Absolutely.
And the last way the deck was stacked against me was that so the victim's clothing, and specifically a bra, had been admitted into evidence. And that correlated with one of the statements in my coerced false confession in which I said that I ripped the victim's bra off. The jury asked to see the bra. And that was a bright spot for the defense because we thought they're thinking like we want them to think, because some bras it would be physically impossible to rip off of somebody.
Right.
And the jury asked to see the bra. And it was at that moment that the judge told us that the clothing had been left in the courtroom overnight over the weekend, and that apparently the janitors thought it was garbage, and they threw it out.
I didn't know that.
And he substituted the actual clothing item for substituted a photo for the bra in which he said,
the same.
No, and he said, quote unquote, this is like verbatim here, you can almost see the bra in this photo. And he refused to grant the mistrial or strike testimony regarding it. So the deck was stacked against me in all those aspects. And the last thing I'll quickly mention, that I was 17 at the time of this trial, and I was completely in over my head. I did not fully understand everything that was going on. And my lawyer took an extreme view of the attorney-client privilege, to the point that he would not allow any adult male member, like none of my uncles or even my mother. He would not allow them to participate in a conversation with him and me.
I would not do that.
When it came to making important decisions, such as whether to testify or not. And I didn't understand what I was...
No, especially, and I allow it with adults. I always say to them, you're sure you want that person in here? If you do, mom, dad, uncle, bring him in. If it'll help you, my client. But understand, if there's going to be a leak or something like that, if they say something to somebody, I can't help that.
Right.
But at 17 years old. Now, were you a senior when it happened, or had you graduated, or not yet?
No, not yet. I was a sophomore in high school.
At 17? Okay.
Yes. Well, I failed a grade.
I see.
I was picked on in school, and I was on the fringes, and so rather than go to summer school and then pass and be stuck with those same group of kids that picked on me, I made the conscious decision not to go to summer school so I could get left back.
But still, 17, even in the eyes of the law, you're not an adult yet.
Right.
For purposes of contracts and all that. So
correct.
I think that attorney, and again, I don't like to play Monday morning quarterback, but based on what you told me, he should have allowed to have other people in that room. Even like your uncle, he said was a marshal.
Yes.
Somebody like that can give you a perspective at 17. You know nothing.
Correct.
Especially about these, it's not like you're buying a car. This is going to affect you profoundly for the rest of your life.
Yeah, you're right.
And it did. Now, were there Brady violations at the trial? And again, just for the audience, a Brady violation is when a case is being investigated and ultimately a defendant is charged, there's evidence that's gathered that the DA has to turn over to the defense attorney. And it can be anything that can exonerate or can be used for impeachment purposes. And it's pretty broad. The problem here, we have prosecutors often that withhold things, thinking, I know the theory of the defense case, so I don't think it really fits into what they're trying to do. No, you got to turn it over. A Suffolk County DA lost his job recently because of that. A Nassau County ADA lost her job because of Brady violations. So you now know what Brady violations are. We talk about it often on my show. When Frank Vetro and I did radio a while back, we were the only group talking about Brady violations, but it profoundly affects people. So were there Brady violations in your trial?
Yes. Specifically, the medical examiner had been complained of by district attorney and other law enforcement in a neighboring county where he was moonlighting as a defense expert. There was concern that he was not testifying truthfully over there.
Even from the prosecutor?
Yes, because he was a medical examiner in Westchester County on the side of law enforcement, even though as a scientist he's supposed to be objective and neutral. Right. That aside, he's still working for the government.
Sure.
In neighboring county, he was not working for the government. He was being hired as an expert, like a defense attorney might, and he was being complained of in neighboring counties that he wasn't giving truthful testimony. So that documentation had been withheld. So there was that aspect of it. And then
When did you learn of that?
during the discovery process of the lawsuit, 16 years later, after I was exonerated.
Of course, well after the trial.
Well after the trial, yes. And the second aspect of it is that when so there was a hair comparison made, and when it didn't match me, the prosecutor resorted to arguing by inference. He suddenly claimed, well, these hairs, which originated, he said, from a person of Negroid and Mongoloid origin, whereas I'm Caucasian. So when the hair expert learned that that was the way the prosecutor was going to answer that piece of evidence, he asked the prosecutor to provide him with hair samples from both of those individuals so he could do the actual comparison. And that evidence was never turned over to him. So I never knew of that omission.
See, it's unfortunate that, and obviously you know Frank Vetro very well.
Very well.
And I represented him after the conviction and civil cases and criminal cases. And he did not know a lot of the things that his attorney hadn't been given until years and years later.
Right.
Which is a problem because, for him, he didn't really serve jail time the way you did.
Right.
But if he didn't bring that lawsuit, if you didn't bring a suit later on, you would have never known about this.
Correct. Yeah, which is one of the arguments that I use. This is my capacity as an advocate. A couple of years ago with the It Could Happen to You coalition, we were able to gather a lot of the groups and advocates together, and we helped pass discovery reform in New York, which pertains to sharing information between the prosecution and the defense. And one of the arguments that I used to make as an advocate working with that group is that, it's backwards that I have greater discovery rights as a plaintiff bringing this federal lawsuit than I did when I was a defendant, originally defending myself against the false charges, which ultimately caused, that resulted in my being wrongfully imprisoned.
Right. And too often, the prosecutor they hold the cards. And I always say, the most powerful law firm in every county is the district attorney's office. No question.
Absolutely.
More than the county attorney, you could have the greatest law firm that ever existed. They don't have the resources that the DA has. And they get that information. So even let's say the OJ trial, that defense team learned about things because it was a high profile case. People call them. They get random calls. Oh, by the way, this guy used the N-word 20 years ago in a book, and he happens to be a witness. In a case like yours, which wasn't necessarily, and the murder cases tend to be more high profile than other types, but your case wasn't the OJ trial.
No, it certainly wasn't on the level of OJ. We got plenty of pretrial coverage, but nowhere near OJ. You're correct.
So less opportunity for people, let's say, OJ is a California, people sitting in New York could say, oh, I remember when that witness said this or that. So as a defense attorney, things are going to fall into your lap in a very high-profile case, like an OJ case or somebody like that.
Yes.
In your case, less so. So your defense attorney is relying on the honesty of the prosecutor to turn over that documentation. If they don't do it, like you said, as a plaintiff, you, Frank Vetro, other people I've heard, got information that they didn't get at the trial. And had they gotten it, it would have made a difference. And then years later, they maybe argue, or you told me a little while ago, harmless error. There's a thing called reversible error, where the case would go back, potentially, or harmless error. So tell us a little bit about where you've heard cases where clearly a violation, but they called it harmless error.
Well, in the John Juca case, I know Doreen.
His mom is going to be coming on next week.
Yeah, absolutely. So the prosecution, withheld information about their last-second jailhouse informant, and then which showed that he was supposed to have been violated a number of times for violating probation conditions, and then he had psychological issues, which that was never informed to the defense. And then that was compounded.
Of that witness, you're saying?
Of that witness, yes. And that was compounded by the prosecutor's argument to the jury, well, he has nothing to benefit. He doesn't have anything to gain. For once in his life, he's trying to do the right thing.
Exactly.
Okay? So that was an example. And then the appellate division, in fact, unanimously reversed John Juca's conviction on prosecutorial misconduct grounds, the Brady violation. But then the Court of Appeals reinstated the conviction in a 6-1 vote, arguing that it was harmless. But the whole thing, let me ask you, you were a lawyer, okay? Still are.
Still are.
Okay. Do you bother to engage in tactics in the courtroom if you think it's not going to help you?
Absolutely not.
It's a waste of your time, isn't it?
It's a waste of your time.
So of the prosecutor thought that something was harmless, right, they wouldn't have bothered to engage in the misconduct. That's what frustrates me. And to me, the last point I'll make on this is that once misconduct has infected a case, the lens of that case, right, the way it's viewed,
Sure.
everything is irreversibly altered. The whole view and trajectory of the case is different at that point.
Right. See, and I know as a practicing attorney for 30 years, former prosecutor, that cases like a drug case, they're more likely to follow the law more exactly and toss it than they will in a murder and a rape case because there's more of a victim.
Right.
And I've seen, if you see a lot of the cases where they toss out a conviction, a lot of times it's drug cases. Like they illegally got the drugs from the guy's house. We're tossing that. But then you have a murder case and, well, they illegally got that scarf that had this on it, but they don't say it this way, but it's a murder and rape case, so we're going to allow that in because we want to make sure that this guy gets convicted. It almost seems like that.
Yeah.
So
It does seem that way.
the law is the law, and you said even though you fight for legislation, it's got to be followed.
Yes.
If it's not followed, it doesn't matter.
Right, because ultimately, you run over someone's rights in order for them to be found convicted because you use the seriousness of the charge to justify that. In the end of the day, everybody's right to a fair trial, but is ultimately compromised. And to me, the only way of restoring somebody's right to a fair trial once misconduct has happened is to, in fact, give them another trial. When we say toss, we're not saying, hey, let's let him go. We're saying that this conviction was obtained in a tainted way that's a violation of either their constitutional rights, their rights under the New York State Constitution, right, or other courtroom procedure, court law, judicial law. So the only way to restore that is let's give them another trial that's fair. Okay. And that's all we're saying. And if we can have a fair trial, then we can have a lot more confidence in the accuracy of the outcome.
Right. And again, if that's the wrong guy, you better start looking for the guy that did it. Or
Yes.
the woman, depending on the case. Now, you have a foundation called the Jeffrey Deskovic Foundation for Justice. And you said you work with also It Could Happen to You. There's a coalition. Tell us a little bit about your foundation.
Yeah, so I started the foundation using some of the money I received as compensation. It took 5 years for me to get compensated for what happened to me. And at that point, I wanted to go beyond just the public education and legislative part to it. I wanted to actually get into the exoneration game, so to speak, to help directly free people. So I started the foundation, and we've been able to free 7 wrongfully convicted people. Oh. And we also are able to help pass legislation pertaining to identification procedures, videotaping interrogation, DNA data bank. So It Could Happen to You is a statewide coalition, and it's made up of exonerees, people falsely accused. But
is that a private or government?
No, it's a 501c3. It's yeah. So people falsely accused but acquitted, criminal justice reform organizations, formerly incarcerated people, individual advocates, friends and family of people who allege that they're wrongfully imprisoned, and just everyday concerned citizens. So the idea is that it's easier for the legislature to ignore an individual organization, the go-it-alone approach. But if we have a statewide coalition, then we have a better chance of being heard. And so working with that group, we were able to pass some legislation in New York. I referenced discovery before. Before that, we were able to pass the country's first Commission on Prosecutor Conduct, so an independent oversight board for prosecutors.
And I'm sure you got some pushback on that one.
Oh, yes, we did. We fought against the District Attorneys Association of New York. They were kicking and screaming during the whole 8-year fight. Mm-hmm. But eventually, we got it passed because there were many wrongful conviction cases coming out in which prosecutorial misconduct was a factor. Mm-hmm. And so we had that, and we did a white paper, and it cost this much money just for these 10 cases that could have been avoided. So we had an argument for any elected official, and it was a bipartisan piece of legislation, which is what I loved. So our sponsor of the bill was Senator DeFrancisco, who was a conservative Republican from upstate New York, and then on the Assembly side we had Assemblyman Nick Perry, who's pretty much I won't say he's left of left, but he's a Democrat, and he's pretty solid, in that political view. So we passed the bill. So in terms of what we're doing now, so the District Attorneys Association, they brought a lawsuit challenging the constitutionality of the statute, and the judge rejected all of their arguments except for one. He found a problem in the appellate procedure.
It was a Court of Appeals now?
No,
did it go to the Court of Appeals?
No, it did not. No, because We thought that the judge's decision in finding a problem with the appellate process, we thought that he was correct in that, and so we're repassing the legislation to make
rather than fight it.
Rather than fight it, we're going to just repass the bill. Let's take in. He gave us a roadmap of what at least one judge thought would be an acceptable.
That's a smart thing to do, because too often a party will just fight, even if they're dead wrong. Now, as far as, and look, I'm a former prosecutor, so I'd like to say this. It is a very, very tough job, very important job, as being a prosecutor. And I want to say my experience has always been, as an assistant DA and dealing with them, positive. I don't think, just like with cops, I don't think there were all these DAs running around that want innocent people to be convicted. But what I think happens sometimes is some prosecutors get a case. There's a lot of pressure on them to get a conviction. In your case, a 15-year-old girl was raped and murdered. The prosecutor thought it was you. Just like a cop who makes an arrest. He believes that person committed that crime. But if the rules aren't followed, right, the wrong outcome can happen.
Right.
That's the problem. So I think some prosecutors, like I said, if you looked at it, would you say most prosecutors want the right outcome?
Yeah, I would say most of them do.
Because I don't know, think of, or even a cop, who wants the bad guy to still be out there? If you're a true prosecutor, when I was a prosecutor, I wanted to get it right.
Yeah, sure.
Do I know everything? Was I omniscient? No. But you want to get it right. And when you're a prosecutor, you have a lot of power to make sure you get it right. Just like with an investigation with the police. They can steer the investigation in a certain way. They can question people in a certain way. They can withhold things in a certain way. But they got to follow the rules. And I think some of the legislation you're working on is toward that end.
Yeah, it's absolutely towards that end. And I want to just piggyback off your point, which is to say that there tend to be serial violators. You know, people, once they do it once and then they keep going,
sure.
And before you know it, the culture, changes. So, I mean, the whole theory of having the commission is that there would be an independent body that has subpoena power.
Yeah, oversight.
The oversight. I mean, every profession has it.
Sure, we have it. And I got to say, I would say lawyers will be more likely to call out other lawyers than maybe doctors would call out other doctors, or engineers would call out engineers. Because, think about it. If I did a closing and a check bounced, that was an escrow check, I have to do something about that. Otherwise, I can get in trouble. Whereas maybe one doctor might cover for another doctor. So lawyers, I think we get rat out all the time, the bad ones anyway.
Yes.
And that's how it should be, because they will give us a bad name, especially with a criminal case. Look at the consequences, not just money.
Right,
it's people's lives.
Yes.
And then when in some places, I don't know if they really exist much anymore, maybe a few limited places, the death penalty.
Right.
That's a whole other show.
Right.
Which we've talked about. I used to be for the death penalty. I got to admit it. I used to be for the death penalty. I remember one time at Fordham University, and at one of my classes, debating a Jesuit priest, where he was against the death penalty, and I was for it. And I remember, and it's funny, that was a culture at the time where you could speak your mind. Now some colleges, if you have a conservative position, you might not want to say it too loudly if you want to get a good grade. But back then, I could speak my mind. I loved it. Now, I look at it as, when I see things like what happened to you, Marty Tankleff, other things you read about, how could you be for the death penalty? Not even from a morality position.
Just from the risk of executing an innocent person, which they made a study that came out that they estimated maybe as many as 4% of the people on death row were actually innocent.
Right. And the thing is this: if, let's say you were put to death,
yes,
the right guy would have never been found. Think about that. The right guy would have never been found if they put you to death.
Yes, exactly. I want to point out, and piggybacking off that point, the majority of people that are exonerated, by the time they're exonerated, it's normally through a post-conviction procedure, not through an appeal. The appeals have typically been over and exhausted a long time, and then the exoneration happens years later when some new evidence is discovered. Now, in applying that context, the framework, to a death penalty case, when the appeals are over, they're going to carry out the penalty. They're going to execute. Unless the governor intervenes or something. Yeah, barring some extra, ordinary type of, intervention. The penalty is executed and the defendant is executed. So they wouldn't have been alive to have been exonerated.
Right. Now, have you heard about any cases where the technology didn't exist at a particular time to exonerate someone, but thank God evidence was kept? And then years later, I've seen TV shows about that, where all of a sudden now they have a better DNA test, or they have something they didn't have then. Have you seen that, or have you used new technology to exonerate somebody that was convicted?
Well, you're looking at somebody right now who is freed who's only home because of the advancement of DNA technology. Let me quickly put some color to that.
Sure.
So before I went to trial, the DNA did not match me. So back then the technology was RFLP. So they could only compare DNA from a crime scene to a particular suspect. They compared that to me.
There's no database or anything, right?
That's where I'm going. What changed 16 years later, it's fine. What changed was that the DNA data bank was created, which allowed them to take crime scene evidence, put it in the database, and compare that to everyone in the database, and it matched the actual perpetrator. Because remember, when he killed the second victim, he got caught, and as a result of that, his DNA was put into the data bank when it was created. And so in that way, it incriminated him and exonerated me, and I was then able to take that evidence and argue newly discovered evidence.
So if he had never been convicted of a felony, because that's the law, you have your
correct.
felony, you got to do the swab, you might not have been exonerated because there was nobody to compare it to.
Right. Yeah, exactly right. Yeah. With the caveat that, I remember they did move to include certain misdemeanor convictions. By the way, I'll share with you, okay, just as an advocate, when that debate was being held legislatively, whether to expand the database or not, I was a proponent of expanding the data bank
to misdemeanors,
even though everyone else in the innocence community and on the defense side had a totally different position. For me, innocence was key, and I wanted the database to be as big as it could be to maximize the chances that an actual perpetrator would be caught. So thereby, bringing him to justice and exonerating the wrongfully convicted person.
And I think that's fair because, look, obviously, I don't have to give my DNA. I'm not charged with anything. I'm not convicted of anything.
Right.
Anybody, we have rights, But a felony, we know, you have to, you had to. Now misdemeanor. So it's not that much of a leap. It's still somebody that committed a crime. You're in a database. You have to look at the pros and cons. A person's rights, but also the ability to get somebody down the road that committed a crime, and if the misdemeanors were not included in the database, a lot of cases would not be solved.
Exactly right, yes.
So we're not talking about a violation of law.
No, we're not talking about a violation.
Traffic ticket.
We're not even talking about if you were charged but acquitted. We're saying upon conviction. Yes.
Upon conviction. It was interesting. I was listening to a seminar, which I hate to do the seminars online. I like to be sitting in. I'm old school.
Of course.
And one of the things was evidence, and this is very fascinating. You should watch this. It talked about when you impeach a witness, you can say, "Were you convicted of a crime?" And however, if they're still in the appeals process,
they can say no.
Right, and you won't be able to get an answer because technically they may have been found guilty at the trial, but in the appeals process, what if they're cleared?
Right.
Then the answer, it's like retroactive. Then you didn't do it.
Right.
Like, look, it'd be like saying, well, you were a murderer for a period of time. You were exonerated. So it goes all the way back.
Right.
So even though you did time for a crime you didn't commit, if someone asked you a question, were you convicted of a crime?
Yeah, legally I'm allowed to say no because it's as if it never happened.
It's as if it never happened.
Yes.
Right. So anyway, so tell us about, this is what I wanted to ask, and people often ask me when I talk about who's coming on my show. How do you get business? How do you get referrals?
So people hear of me. I do a lot of media interviews, television, radio, print media, new media, and so friends and family of people who are in prison bring me to the attention of the prisoners. But then also I'm kind of a legend in the law libraries throughout the New York State prison system.
Do they name any libraries after you?
Not yet, but I would like one though.
Okay.
Yeah. So people hear
gotta
of
work
me.
on that.
People hear of me, and like I said, I do a lot of media and I speak out. I'm not like one of those people that once you're exonerated, you get your initial hit of 5 minutes of fame and you disappear. No, I've kept the ball rolling and I figured out how to stay current. And then my life is this. I didn't just transition to a normal life. I eat, sleep, breathe, fight in wrongful conviction.
And with a law degree, it gives you a little more power to be able to do that.
Yeah, absolutely. That was why I decided to go to law school. I graduated Pace Law in May 2019. I'm pending admission right now. And so I want to be able to free people as the attorney. And then also, I know that the law degree, that extra credential will help me in my policy initiatives as well.
I think it does. Gives you a little more oomph. juice,
Yes,
as I would say.
it does.
Now, but when someone comes to you and says, I have a cousin who's in jail and he didn't commit that crime,
Yes.
do you send somebody to talk to that individual? Do you say, give me some of the file? How do you sift through it? Because not everybody, I'm sure, that says they're innocent is innocent.
No, absolutely not. No, we have a vetting process, and we're not that naive to think that everybody that claims it is. Because I was innocent doesn't mean everyone else who's saying it is. So,
like the jails are all full of innocent people, like the joke goes, right?
Like the joke
there are
goes.
innocent people in jail, but
Yes.
how do you sift through? What's your vetting process?
Sure. Our vetting process is we ask for certain legal documents. So specifically, we ask for the direct appeal briefs from the prosecution and the defense. And the way that we use that is that's our cliff notes. We use it just for the factual section, because only if we approve the case would we then go into the actual transcript and read several thousand pages, right? So we ask for that. We ask for the police reports, if there's any lab reports, and if there's any expert testimony beyond the medical examiner. And we have them fill out a questionnaire. So the first thing is we look at the questionnaire and we see what pieces of evidence were used. We cross-check that with the appeal briefs, make sure no one's left anything out. And then we undergo a second level of analysis in which we scrutinize what was used as evidence, right? And we know, say a case had a confession in it. Well, we know what the red flags are that a confession was coerced and false based on the exonerations that have happened through DNA and false confession cases. So we look at the evidence and we look for patterns and red flags as established by other cases that have already ended in DNA exoneration. So we look at that. So we ask ourselves, does the applicant have at least a colorable claim of actual innocence? And number two, do we see a potential route for victory? Because once you've been convicted, the burden of proof shifts to the defendant, and you now have to prove that you were innocent. So only if we say yes to both of those questions do we actually take a case. Let me give an example of a case that we declined to take. So the defendant, there were weapons found in the applicant's in his room. It was in the house, and his argument was, well, I was renting a room in the house, and so anybody had access to my room and could have put the guns in there. So we wrote back a letter and we said, yeah, but like, tell us about the other people in the house and why would they take a chance at storing firearms in your room where you could walk in at any time and find them? And his answer to that was, well, the cops searched my room in violation of my Fourth Amendment rights. So that evidence was improperly admitted, and we therefore want you, an innocent entity, to exclude that from your calculation as to whether you think that I'm innocent or not.
You gotta look at the picture.
And that didn't fly, obviously. It was laughable, actually, and we said next. But the unfortunate thing is the time that we did spend on that case could have better went to somebody who was actually innocent.
But you don't have a crystal ball, so.
We don't have a crystal ball.
There comes a time when you're vetting the case, there's an aha moment.
Yes.
And could it either be, like in this case, there was an aha moment, no, we're not going forward with this.
Right.
When you have the aha moment and you said, you know what, this guy might really be innocent. And a 440 motion probably comes into play in a lot of these cases.
Yes, absolutely,
okay?
of course.
Who does that 440? Does he have to have an attorney do it? Do you guys do it for him? How does that happen? A 440 motion, you can just explain a little bit.
Yeah, so a 440 motion is a post-conviction motion, and it's different from an appeal. So what a 440 motion is saying is that I'm going to enlarge the record and put new facts in that wasn't known, and I'm then going to make legal arguments based on those facts. And you could make an actual innocence argument, and then you could also make a newly discovered evidence argument. You can make a Brady claim.
Pretty expansive. Yeah.
Pretty expensive. All right. So previously I had hired staff, and so in-house we were actually filing the motion. Yeah. But frankly, our fundraising didn't go well, and so after 3.5 years of just writing a large check, I had to get rid of the paid employees and convert the entity to a volunteer entity, and so.
Law students, things like that?
Yeah, so we have interns, law students, and when we vetted cases, there's about 5 lawyers that work with us, and they're looking for a good case where someone is innocent and they see a route to victory. We pitch the case to them, which includes our battle plan in contemplation of their taking the case pro bono and carrying out our plan and filing the motion, in which we would remain consulting with them and contribute timely media and other grassroots tactics. So that's the way we're working now. We have 10 cases that are active. There's another 5 that are approved and waiting. But that's just to have something to do now. But really, the goal is, I mean, the process of trying to raise money to, again, have full in-house staff, investigators, paralegals, and attorneys.
That can really focus on those.
Yeah, let's go hard 40, 50 hours rather than I'm going to rely on Phil. He's going to do the case, but he's going to fit it in between all of his other work.
Students have a lot of other things on their plate.
The students and even the lawyers, even the lawyers. But we would rather have the better way to do it.
That's your job. Do what you got to do.
Yes, that's it. Give 40, 50 hours every week on this case, and let's get it done.
Now, I'm sure you've had cases where a 440 motion was already made, and you can get a lot of information in those 440 motions. I remember before I had Marty Tankleff on one of my shows, I went through the 4040 motion. And that's what really convinced me of his innocence. Because, in an appeal, in an appeal you can find that information too, but in the 440 motion, there were things that were put in that 440 motion, like, for instance, and you know this, polygraph test. Polygraph tests are allowed in 440 motions, but they're not admissible, not in New York, New Mexico they are, but at trial.
Right.
So a 440 motion, you can throw in there, this particular witness failed a polygraph. Well, he passed the polygraph. You're not going to see that at a trial. Now, is it perfect evidence? No, but it gives you an idea of something.
Yeah, and just for our audience, I mean, you're not going to win the case based on that, but if you have something else, that can't be your lead. But if you have some other piece and then you throw that in, that can be a persuasive secondary factor that the judge will take into account. And certainly in terms of as an attorney or as an organization, the fact that your client took and passed the polygraph, that would certainly be a confidence factor internally as to why you might go ahead with the case.
Right. Well, would you take a case if you found out that the defendant you were going to put a lot of effort into exonerate pitifully failed a polygraph test? Is that something you consider it, of course, right? In terms of other things?
So I've never been in that scenario. I would have to consider whether I wanted to go forward with them or not. It would be a question. It's not an automatic no or yes, because remember also, right, the reason why polygraphs, with the exception of New Mexico, you mentioned, are not admissible is because they're not scientific, and sometimes they are, in fact, failed by frightened, innocent people. All right, the whole premise of the polygraph is that when a person tells a lie, you'll become nervous, and that will result in an increased pulse rate.
Right.
The polygraph measures the pulse rate, and in fact, I failed the polygraph test by law enforcement, just as an example. Of course, that was under much different conditions than what we're talking about it would be, because the polygraph is expert. In my case, he was a Putnam County Sheriff's investigator, and he carried out this procedure, which he referred to as GTC, get the confession.
I see.
So it was not exactly, even as unscientific as polygraphs are. Remember, intelligence agents are trained on how to beat the polygraph in case they're captured when they're undercover. Right. But even all that as it is, even by that unscientific measure, that was not the procedure that the polygraph is carried out for me.
Right. Yeah. Like, in fact, very quickly, in the Tankleff case, in the 440 motion, the night that the parents were killed, a witness later on said, I drove 2 individuals to the Tankleff house in Belterre. And he said the next day, he went to one of the witnesses' houses, and the guy was in the backyard with like a drum burning, I think, the hoodie and the jeans that he had. Wow. That's pretty powerful.
That's really powerful evidence.
Powerful. Like, what's the motive of getting rid of your jeans? And the night before, and so that guy underwent a polygraph. The witness, the driver of the car, and he passed the polygraph. So that's something, again, not meant for a jury, but a judge, let's say, deciding whether or not you get back in the game. That is very, very powerful.
Yeah, it certainly is.
Extremely powerful information.
Yes.
And that was in the 440 that I read.
Yes. Yeah.
Because, in fact, I was in the office when the Tankleff murder. I wasn't a homicide prosecutor, but I remember it. And your first thinking is, oh, he confessed, right?
Right.
You always think of, if there's a confession to the layperson, he must be guilty, right? Like you said,
yeah, it's common thought.
There was a confession in yours, but you got to look deeper than that. But it does, potentially taint a jury.
Oh, for sure.
Because they're going to say, I would never admit to something I didn't do.
Right.
But so it happens.
Right. And addressing that point, so from the body of exonerations that have happened through DNA evidence, coerced false confessions have been the cause of wrongful convictions in 25% of those cases.
Wow, that's pretty high. Wrongful, so a quarter of the time, DNA exonerates a person, but that same person made some type of admission.
Correct.
In the
yes. And then going beyond that, false confession experts have determined that while adults have given coerced false confessions, that particularly vulnerable populations would include youth and people with mental health issues.
Sure, it's easy to break them down.
Yes.
And you can make promises, hey, look, just say you were there, and it might not even be a full confession. Say, look, just say you were at the scene, right? And maybe, you don't know what happened, and just say you're at, and then they put the person at the scene who might not have been at the scene, but he, in his mind, okay, I'll just say I was there, but I didn't do it. I'll sort this out later.
Right. Yeah. A lot of people think that they'll sort it out later. And threats come into play, false promises. So I was given a false promise, for example. So they played the game good cop, bad cop. You know?
Sure.
And the cop who was pretending to be my friend, who I was also looking up to as a father figure, he told me, look, the other cops are going to harm you. I can't hold them off anymore. Just tell them what they want, and you're going to go home afterwards. Look, you're not going to be arrested. You're going to go home afterwards.
You're a 17-year-old kid, scared out of your mind.
16 at that point.
Wow.
Yes, remember, the 17 was at the trial.
That's right.
The arrest was 16. Yeah, and he says, look, you're not going to be arrested. Just tell them what they want to hear, and
sure.
and I believed it. Unfortunately, I was desperate and I was frightened. But another point I wanted to make is when you're in that moment, you're not thinking about the long term. You're just trying to get out of there.
Exactly.
Yeah.
Right. Now, I remember in Marty Tankliff's case, I think it was his first day of his senior year, and he was told his father had survived.
Right. Yes.
And his father said that he did it. So he's being told these things, and again, he's about 17 at the time, and you're thinking about the moment. You're not thinking, no 16, 17, or even person in that position is thinking, well, at trial, that's going to be a problem for me. They're not thinking about it that way.
No, they're not. And now, in Marty's case in particular, so there's two different types of coerced false confession. You have the coerced compliant, right, where the person is just coerced into making a false confession.
Like a phone book that they used to use in Suffolk County years ago?
Right. And, and obviously the person...
Beating him with a phone book, that is.
Yeah, of course. The whole theory with that is it doesn't leave marks. That was what that was about.
Exactly.
But the person who's making the confession is well aware of the fact that they're innocent. But then you have what's called the internalized false confession, which is when the suspect momentarily doubts their old innocence. So in the Tankliff case, them saying, well, that his stepfather came to and said that you did it, it caused Marty to momentarily doubt his innocence. Now he shortly recanted after that, but that one moment, and it was too late. But I want to just add one other quick point that I didn't make before, talking about false confessions, which is that the innocence of a suspect can work against them in terms of their decision whether to waive their rights or not.
Right.
The police would, anything you say can and will be used against you in the court of law. So the innocence of suspects works against them in the sense that they think that, well, I didn't do it.
So and
I don't know anything about it either.
So they'll never be able to convict me.
Exactly. What can possibly go wrong if I waive my rights and speak to the police without an attorney? But actually, quite a bit can actually go wrong.
A very dangerous attitude. Did you testify at trial?
I did not. That is a really big regret that I have. My attorney told me not to testify. In hindsight, it was clearly the wrong decision. So there's an 80% conviction rate in cases that have a confession. So if you're defending your client and there's a confession, as you said, the common thought that the public has, and the jury's made up of the public, is, well, I would never confess. So if you're behind the 8 ball if you're facing that as evidence. So you have to answer that confession. Your client has to testify. You have to explain why did you falsely confess, right. And then your lawyer secondarily has to try to disprove as many aspects of the confession as he or she can. In order to marshal it all together in that closing argument. My attorney didn't do any of that. Wow. He wouldn't allow me to testify. So remember, in my confession, I was threatened. There was a false promise. The cops left it out of their testimony. I wanted to testify to add those facts to it, but he wouldn't allow me to. He didn't present my alibi evidence. He didn't try to attack the confession when his defense's turn to present the case. And as a result of that, I was convicted. I spent 16 years in prison.
If you hadn't, let's say, given a confession, you're saying then that might have been the right decision not to testify. But because you had confessed, the jury's left with that confession.
Yes.
They want to see you say, I didn't do it, why I confessed, or why I said what I did. They want to see that.
Yes, absolutely. They absolutely want to see that, yes.
Because without that, they're going to say, he didn't give me a satisfactory answer. Even though the burden is not on you to prove your innocence, let's be honest.
Let's be in the real world. Let's practice
Right.
law in the real world. Let's move past the legal maxims. And in reality, if there's a confession and you have to answer that confession, you got to get up there on the stand and say that you didn't do it, and you have to explain why you falsely confessed. And then as many ways as you can disprove each fact in that confession, as many as you can disprove, or even show that the police gave details. That's all key. That is strategy. That's strategy 101.
And don't forget, the prosecutor has the burden beyond a reasonable doubt. If you can punch holes in that confession,
Right.
and I've done this before in cases that I've had, where you can punch holes where the jury's left with, I don't know what the heck to believe. As a
Right.
defense attorney, that's beautiful. As a defense attorney, you want the jury to say, we don't know what to believe. Because
Right.
what does that mean? That's reasonable doubt. I had a case very quickly, we're running out of time, where there was an allegation of a threat made over the phone. There was a tape. It was hard to tell. It wasn't the world's greatest tape. The DA had my client's phone records that the call was made. My client came to me and said, I never made that call. So I contacted a spoofing expert. You heard of spoofing? And he's saying, I never made that call. I went out and got his records from a different source. No phone call. So the DA gets up there and says, I have his phone records. He made the call. I got up there and I said, I have his phone records. He didn't make the call. He was found not guilty because the jury didn't know what to believe. I spoke to them afterwards. And they're like, when we heard there were phone records, because the prosecutor goes first, although in my opening, I was very suspect. I didn't want to raise the bar too high.
Right.
And so the jury said to me, when the prosecutor has a phone records and your client's saying, I didn't make the phone call, he's guilty.
Yeah, of course. Yeah.
But then we see records from another reliable source that I got into evidence that says he didn't make the call. What do you think? So the same thing with the confession. You have to give your attorney has to do something.
Yeah, give a competing narrative.
Give a competing narrative to say he didn't make the call. So even if the jury says, I don't know what to believe,
That's still a win for the
that's
defendant.
still a win for the defense.
Because the burden of proof is on the prosecution, guilt beyond a reasonable doubt.
We only have about a minute and a half left. What are your goals for the future? I know you said you want to hire a full-time staff. What next level do you want to get to?
I would like to get to the point where I have a full-time staff, attorneys, paralegals, investigators, other essential personnel on staff. So I'd like to be able to ramp up our case capacity. We're trying to repass the commission. We're trying to get rid of the exceptions to videotaping interrogations, and we're trying to bring that oversight to other states. And I'm hoping to not be pending admission anymore. I want to actually have the law license, exonerate a lot of people, and help them get compensated on the back end. I'd like to increase my profile.
Right, and not just a New York
Not just New York
organization.
Right, correct. The
National.
ultimate dream is I'd love to copy the ACLU model in the sense that they have an office in every state. So wrongful conviction is a problem countrywide. It's a problem worldwide. So the ultimate goal would be to have an office in every country. The only thing is, Phil, in that the other countries, you don't hear about the wrongful convictions, not because they're not happening, is because nobody's being exonerated.
That's right. Now, I want to just use a hockey analogy. In the movie Miracle, when he's talking about how he wants to take on the Russians and win, one of the guys from the NHL said, that's a lofty goal. And his answer was, that's why I want to pursue it. What you're saying is a lofty goal.
Yes.
Right? And even if you don't get to that level, you're going to get to a bigger level than you are now. So shoot for the stars.
Yes.
And even if you fall a little bit short, you're going to be a heck of a lot closer than if you just sit around and opine as to how things could get better. So I really want to commend you. You're doing a great job. I'm going to have you on my radio show. Anything I can do to help you out. I try to be there on the second line. You're on the front line. I want to commend you for that. Thank you. I want to thank my viewers and the listeners. I'm also on Facebook and I'm also on YouTube. It's Phil Jusino is the YouTube channel. If you missed this show or other shows, go to that and see it. And you'll be hearing more from Jeffrey Deskovic. Thank you. Oh, go ahead.
I just want to say, if people would like to get in touch with me, they can email through the website, deskovic.org. We're always looking for people to contribute to the cause and help in other ways.
Very good. You have a great day. Take care.